please the court, Mr. Summers, co-counsel, members of the jury.
Okay, Art and Landon, I need to give you guys some information, and I want you to make sure you understand this. I spent a lot of time with Mom the last few hours, and the things that she's told you about me being good at manipulation, control, and lying is true. And tying her up.
That is Trevor Summers in a nutshell. Manipulative, lying, controlling. And Elisa Mathewson finally had the opportunity to stand up to him on that witness stand this week. She finally got the opportunity to stand up for herself and tell you exactly what happened on March 11th, March 12th, and March 13th. The defendant chose to represent himself, and that you have a special instruction in which to consider that. You are not to base your decision because you feel sorry for him, because you dislike him, or because you like him. You are to base your decision upon the law and the facts and evidence that have been introduced during this trial. The same goes for any witness that took the witness stand and the attorneys in this case. You must not make any decision in this case because you like or dislike anyone. It must be based solely upon the evidence and the law and the facts in this case. I'm going to touch upon some arguments made by the defendant a few moments ago. He said that there were no dents, no glass broken, no blood at the home. Did Miss Mathewson ever describe the incident of her being pulled from the bed by her feet and taken into the family room? Did she ever describe it in a manner that you would expect to find broken glass, blood, dents in the walls? No. She described it that he pulled her from the bed from her feet. She was throwing items at him, and then he guided her out into the family room, and she kept trying to get up and try to run out that door. That's what she told you. So I would submit to you that the photographs that were taken on March 12th of 2017 of her home clearly depict what had occurred. They corroborate what she told you had occurred in that family room. We see the pillows nicely aligned on the sofa that she was laying on earlier that night watching the Storks movie with Bryn and Grady. The pillows are put on the couch in a neatly fashion. Look at the photograph of the way the pillows are on the couch that she tells you that she kept trying to run from the defendant on. They're all on the ground. He says, look at the fact that the cup and the Kleenex aren't where they were. She said she threw them. What do we know about what happened in that room? We know Bryn and Grady were in that room after they were told to go back in the room, after the defendant told them to go back in that room and not come out. We know they were in there for some time, worried about their mom, yelling to their mom, "Are you okay, Mom?" And she yells back, "Everything's fine." Could they have picked up the cup and put it on the countertop, picked up the Kleenex box? We know that Miss Mathewson and the defendant were in that room for hours on the 11th. Is it unreasonable to think at some point when he walked in the room to tie her up multiple times, he picked it up, picked the Kleenex box up? No. He said that she was not tied when he went to Walgreens. Why would he take his estranged wife to go see the children for one last time tied up? The problem with him making that argument is that in his recorded post-Miranda interview, he says that he tied her up. So he's arguing moments ago that he didn't tie her up to go to Walgreens, yet in his post-Miranda admission, he told the law enforcement officers he tied her up. He said, I said, should I at least tie your hand so you don't do anything dumb in the car? He tied her up. Talks about the blisters, the blisters that, why would she go walking in this area, or this area was high brush, high dense area, and that's how she got those blisters. And then he was like, well, why didn't you wear flip-flops if you already had the blisters from being tied up? And she explained, he said they were out in the woods. She described this as a high, densely brush area. And she was not going to wear flip-flops to walk through this, on this journey that he was going to make her go on to go find water. Is that unreasonable? He says in the video that he made that he was being nice and asking her what else he should include in that video. You don't see her in that video. She's not a happy woman who just had sex with the love of her life, wrapping her arms around his shoulders on that video. She's hogtied, laying down. That's why you don't see her in that video. He talks about the Walgreens video. He wants you to go back and watch that video. I'd recommend that you go back and watch it. Because what you're going to see is you see him walking into the store. He goes out of camera for a minute. He comes back in the angle of the camera looking out into the parking lot. And soon thereafter, he realizes that Miss Mathewson had managed to escape from the car while tied up. And he walks out of the store, and if you keep watching the video, he then proceeds to start running after her. And Mr. Crosby testified that he saw the defendant come from the store running to Miss Mathewson. Grabs her. That's how Mr. Crosby describes the interaction. Grabs her and takes her back to the car. After she was yelling, please help, call the police. If that's not kidnapping, what is? Why would he park in front of the store if he had tied her up and she was going with him unwillingly? You heard Miss Mathewson explain over and over again. She was with him for 16 years. She placated for him. She did what she had to do, so there was not conflict. She did what she had to do on March 11th, 12th, and 13th to stay alive. She was staying on his good side. She was going to do what she needed to do to make sure she stayed alive. That's exactly what she was doing this entire time. And it was finally on the witness stand this week that she was not going to placate him anymore. She was not going to go along with what he said. And she stood up for herself. The McDonald's video is a classic example of what their marriage was for 16 years, of her going along with what he said. He had threatened her before they went through the drive-thru, if you do anything, I'm going to hurt you. So what did she do? She did what she had done the last 16 years and just went along. She knew she had to do that to stay alive. He argues to you, if she could have gotten out of the car, I wouldn't have been able to get out of the car. My door would have hit the building. He was in the car. he could have run her over with the car. He had already tried to suffocate her one time. What would stop him from stepping on that pedal and running right into her if she tried to flee? She tried to flee one time. Remember, she tried to flee on March 11th at the Walgreens. She tried, and she was unsuccessful. So she knew from that point on, she had to just go along with what he said until there was another opportunity, or until she was going to be able to convince him to let her go. Watch the Sitco video again. What did she tell you about what happened when they were at the Sitco? She was required to go back to the third row because he knew that the last time he left her in the vehicle, she had tried to run away. So she had to go into the third row and watch the video. Watch his demeanor and his actions in that video. He couldn't grab that dip fast enough from the employer or the employee there at the Sitco. He didn't wait for his change. He goes to proceed to walk out, and then he remembers he wants to get a newspaper. Because why? He probably wants to find out if people are writing about what had happened. The kidnapping of Miss Mathewson. Because he had been listening and looking for it on the radio. So he gets the newspaper again. He doesn't even want to hand the newspaper over for the Sitco employee to scan it. The employee almost has to grab it from him to be able to scan it. He throws his money down again, and he leaves. And the entire time that he is standing at the countertop, he is looking out the window for Miss Mathewson. Going back for a moment to Mr. Crosby, he says that he didn't know the make and model of the vehicle. He was more concerned about the license plate. Well, what's more important to give to law enforcement? Is it more important to get the make and the model of the vehicle or the license plate? And he is the most independent, non-biased witness in this case. And recall his testimony. He saw her with her hands tied behind, saw her hands behind her back, running, yelling for help, call the police. And then the defendant, who he can identify, grabbed the victim and put her in the car. He talks about Kimberly Shea, and that she described during cross-examination that she thought possibly maybe her hand was resting up on the door, and that she looked distressed. And Miss Shea, 5.5 years later, the first time she's saying about the hand on the window was through the Zoom testimony, 5.5 years later. She told you she gave a very detailed written statement that included descriptions of both the male and the female, what she observed, the car. But that one statement of hers was not in that written statement. But he wants you to hold on to that so tight. But what we already know from his statement and Miss Matthews's statement and Mr. Crosby's statement is her hands were tied. Because in the interview with Sergeant Remia, he admits that he tied her hands up so she wouldn't do anything dumb. Why would he have to tie her hands up if she had agreed to go with him? Let's talk about his interview for a minute, because he keeps harping on the fact of the medication that he was provided, that Hillsborough County Sheriff's Office didn't follow proper procedure in interviewing an individual in the hospital, that his statement was not knowing and voluntarily made. The state would submit to you that that 37-minute recording speaks for itself. He was provided fentanyl at 12:18. What did Dr. Chesla tell us about fentanyl? It is fast on and fast off. It quickly relieves people of pain, and it quickly wears off. We know that there were other drugs prescribed because they generally give nurses options for different pain management. But he told you that looking at the list, none of them had been given other than the fentanyl. None of the other drugs had been given to him. And listen to his recording again. He is clear. He makes sense. He does the majority of the talking. He says, this is just the cliff notes. I can provide more details if you want them. Those are his statements. He's not saying, I can't talk right now. I'm in so much pain. I don't understand the questions you are asking me. Can you come back? None of those things come out of his mouth. He could not been clear on the facts and circumstances surrounding what occurred those last 2.5 days. The DNA. There was no DNA linked to the sex battery kit of Miss Mathewson, of the defendant's DNA. Well, we know from the defendant's own statement that they had sex. The issue for you to resolve was it consensual or not? So the fact that there's no DNA there, he didn't argue to you that they didn't have sex. What does that matter? The issue with regards to the sex is whether or not it was consensual. And the state would submit to you someone who sneaks in Miss Mathewson's home in the middle of the night, ties her up, the sex was not consensual. It is not reasonable to believe that someone would consensually have sex with that man after he tied her up with scarves, rope, Christmas tree lights. And that's not all just coming from Miss Mathewson. It's his own statement. He tied her up with the Christmas tree lights. So what would the DNA results on the Christmas tree lights give you? He already tells you that he had tied her up with the Christmas tree lights. What else did we learn from the DNA from Miss Montgomery O'Neill? That if people shower, that's going to affect the DNA. If people go to the bathroom, that's going to affect the DNA. And if someone has a vasectomy, that could affect the threshold. But again, the state doesn't have to put the semen inside Miss Mathewson. He admitted in his own statement that they had sex. The issue is consent. He talks about that law enforcement did not follow up on the writings, that whether a house can be transferred via writing, that a car or bank accounts were the correct bank account numbers. The thing with that, ladies and gentlemen, the state would submit to you that he never intended for Miss Mathewson to have any of that stuff. If you look at the note to the children, that explains 100% what his intentions were. His intentions were to kill Miss Mathewson and himself. You decide what kind of letter that was. Miss Mathewson was never going to kill herself. All she wanted to do was get out of the situation alive and to be with her children. He never intended for her to ever get out of that car. So he's going to pretend like, I'm going to let you go as long as you don't call the police. And she's like, I promise you I will not call the police if you leave me these things. But he was never going to let any of that happen. So he didn't care if it was a valid quitclaim deed or a valid surrender of his parental rights, because he knew all along what he was going to do. He knew all along that he was going to kill her. And he was going to kill himself because he was going to be watching his children from heaven. That was his plan all along. He wrote those letters when they had arrived on the Anna Maria Island. They had pulled off. This is coming from Miss Mathewson and his own statement. That's when he wrote the letters. That's when he wrote the confession letter. That's when he wrote the letter of the surrender of the parental rights. That's when he wrote all of these letters, including the letter to the children. But Miss Mathewson never knew that letter to the children was written. She never saw that letter. He was never going to let her know he wrote that letter because she would then know what the plan was. So he's driving around looking for this flag. That's what he told her. He was driving around trying to get up the courage to do what he knew he was going to do all along. He was trying to find the right place. But he didn't find the right place at Anna Maria Island. So then he moves along to Little Harbor. And that's when he had enough courage, he was going to handle it. He was going to kill her then. That's when he got in the third row, and he took the rope around her neck and began to strangle her. And then he jumped in the car and fled because he saw an undercover vehicle. So these writings and the fact that law enforcement didn't follow up on them mean nothing. Because to him, those writings meant nothing. He was never going to let her out of that car alive. He brought up Bryn and that her testimony contradicted Miss Mathewson's testimony. She was 7 years old when this happened. 7. What did she tell you, though? She told you that she saw scars on her dad. She told you that she was in fear for her mom. She was afraid for her. Is that contradictory of what Miss Mathewson told you? The defendant brought up the February 18 incident, and the judge read you a special instruction as to how you are to consider that evidence. And the state would submit to you that you must follow that instruction. And one of the ways that you can evaluate and consider that is to corroborate the victim. He talks about how Miss Mathewson can't remember conversations that they had for the 30 hours that they were in that car. What did she tell you? She told you that he can just talk and talk and talk about nonsense ad nauseum. Nonsense. And he tries to act like that there was this big tumultuous arguing happening over these 30 hours. That's not what Miss Mathewson told you. She was playing along this entire time with him. There was no arguing. There was no tumultuous situation happening. There was no wrestling in the car. Look at the photographs in the car. Are there things strewn about that it would show that there was some kind of wrestling that he wanted to try to say that was happening in the car? And that's why she got those marks on her neck. Because he doesn't want anybody to think that it could have been from him possibly strangling her. The nonsense. His statement, he says about the immigrants and that these boats, about these different times he was going to get these boats. Miss Mathewson was clear. Based upon things in their marriage over 16 years, there were reasons for her to believe what he was telling her. Miss Mathewson's vehicle was not a community vehicle. She left him. She moved into that home herself. She bought herself that car, and she had a job. That was not his car. That was her car. His car was the minivan that he decided to send his 14-year-old daughter in to drive the 12-year-old and 5-year-old and 7-year-old home. That was his vehicle. She didn't even know what kind of vehicle he had just gotten. There were no marital vehicles at this time. He had his vehicle and she had her vehicle. And she didn't give him permission at any time that weekend to take her car. Everyone reacts to a traumatic event differently. There is no one formula or way that someone should react to a traumatic event right after the incident or 5.5 years later. This is not a situation where Miss Mathewson was kidnapped by a stranger. This was someone who she had been with since she was a teenager. For 16 years she had been with him. So she knew what she needed to do to try to stay alive in that situation. And that's why she acted the way she did. Why she acted to try and befriend him, to keep him calm, to try to not have conflict, because she knew after 16 years that was the only way, the only chance she was going to ever have to possibly get out of this situation alive. The topic of a Baker Act was brought up during the testimony of the trial, but it's clear from the evidence and Sergeant Steele's testimony is that the defendant was never Baker Acted. He was booked in at the jail on the 14th. There was no 72-hour hold on him. He was in the jail the next day. Another thing to consider when he wants you to think that he is not of the right frame of mind when he is making his confession. But you don't have to just rely upon that confession. We have the written confession from him, and we have the videotaped confessions from him. He wasn't on fentanyl then. He wasn't suffering from his self-inflicted wound then. You have multiple admissions from the defendant. I want to take you through a few inconsistencies in his statements. He had told originally the victim that he had, Miss Mathewson, that he and law enforcement was the purpose of going in there was to say goodbye. He was going to say goodbye. In the middle of the night, he needed to sneak into her home to say goodbye. But then he tells his 14-year-old and 12-year-old that the reason he needs their help to get into the home is to address legal issues, and that he was going to convince Miss Mathewson to come home so they could be a family again. Let's talk about the wrist cutting situation, because Miss Mathewson was clear in her testimony that he cut her wrist because he was mad that she had tried to flee from the Walgreens. And it was done intentionally and purposefully. In his recorded statement, he tells law enforcement that he cut her wrist accidentally when he was cutting the rope. Well, let's look at the evidence in the case. We have the back of Miss Mathewson's shirt. The way she wears that is you put your arms through it, it buttons down the front, and where all the blood is in the back. So what does that tell us? What it tells us is that her hands were tied behind her back. She was cut because he was mad that she had tried to flee at the Walgreens. And she bled all over the back of her shirt when her hands were still tied together. He never cut her when he cut the ropes off, because if he cut her when he cut the ropes off, the blood would be on the front of her. The blood would be on the front of her clothes. Miss Mathewson knew she would be hurt if she tried to fight again or if she tried to flee again. So she went along with him in order to make sure she didn't get injured. And that's exactly what she told you. The evidence in this case corroborates every witness and every detail Miss Mathewson has told you. He tells you in his recorded statement that he's dead tired, so he had to stop. He had to park and drive in those woods. He was dead tired. If he was dead tired, how can you believe his statement that the two of them slept for hours earlier at her home? They slept for hours together. How did they sleep for hours after they had this consensual sex? And then he be dead tired. He was dead tired because he was up for over 24 hours. There was no sleeping after this consensual sex. He was dead tired of having to tie her up multiple times and keep watch on her, trying to get into her phone, find out who she had been talking to. That's what he was dead tired from. If you listen to his recorded statement, he almost makes a slip up and talks about this letter that he discusses that he and Miss Mathewson are going to watch the children from heaven. When he starts talking to the Sergeant Remia about the letters that he wrote, he says, drove all the way into Anna Maria. Right before Anna Maria, there's a boat ramp. We parked, sunlight starting to come up, and she wanted me to write some things. And she said if I did that, she wouldn't tell the police anything. So I wrote out, that she can have the house, car, the money, and whatever I left. Just said and then she wanted me to write, no, she didn't want me to write that. He almost said that he wrote the letter to the kids when he was talking to law enforcement, but he knew he couldn't admit to that because his whole floating over, not discussing the strangulation in that post-Miranda interview would be shot out of the water. He almost confessed to that, but he caught himself because he knew some of his story wouldn't make any sense anymore. He thought he was going to be able to get away with explaining the suffocation of the pillow as a pure accident, a joke. He was just being an ass. But he doesn't even mention the strangulation. He doesn't mention the strangulation because he knew he wasn't going to be able to cover that up once they had found that letter to the children. So he purposefully leaves that out of his statement. It's not a defense. The fact that your estranged wife joins a dating app, that's not a defense to any of these crimes. The fact that she's dating a man that she's now married to, not a defense to the crimes. The fact that she agreed to go with him at one point and changed her mind, not a defense to the crimes. The fact that she has sex with him and is dating other people, not a defense to these crimes. The fact that he wasn't right in the head, needed to go away, not a defense to these crimes. This isn't an insanity case. None of the reasons he gave Sergeant Remia in his confession are defenses to any of these crimes. The state has the burden to prove this case to you beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. What does abiding conviction mean? Abiding meaning firm, conviction meaning belief. If you have a firm belief that the defendant committed these crimes, you must find him guilty of those crimes. He had made the decision that if he couldn't have her, no one would, or no one could. And all of the evidence in this case corroborates each and every single witness that the state has put forth to you. I briefly want to touch upon the aggravation with regards to a weapon when it comes to counts 1 and 2, because the state has charged him with attempted first-degree murder with a weapon. The weapon in count 1 is the pillow. The weapon in count 2 is the rope. The definition for a weapon is 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. He took that pillow and put it over Miss Matthewson's face, pushed down with all of his weight until she wasn't struggling anymore. He used that pillow in a manner that could be used to inflict bodily harm. Therefore, it was a weapon. The rope. He took it around her neck from behind. The only reason he wasn't successful was because she had her hands tied this way and was able to catch the rope, prevent it from going around the front part of her neck. That rope was used in a way that could have inflicted bodily harm. The state would submit to you, we have proven that the pillow and the rope are considered and are weapons on the March 11th date and on the March 13th date. The facts in this case are almost unbelievable. But with the mountain of evidence that the state has proven to you, has given to you for you to look at and review, tells you exactly what happened and tells you that the facts are not unbelievable. That they are as stated. They are fact, the state would submit to you. The mountain of evidence, the overwhelming evidence in this case points directly to the guilt of Trevor Summers. And we're confident that at the conclusion of this case, you will find him guilty as to each and every count. Thank you.
Gentlemen of the jury, we're going to take a short break. I'm going to give my court reporter at least a little break before I read the instructions to you. It'll also be an opportunity for you to stretch your legs, use the restroom if necessary. It will be a short break. We'll come in and I will read you the final instructions, and then you will return to the jury room to deliberate. Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case. All rise for the jury. Mia, about how much time do you think you need?
5 minutes.
All right. Well, we'll take at least 5 minutes. What I want the parties to do is look through